And to introduce our next speaker, Mr. Robert Bob Metz.
Believe it or not, I actually know the exact date on which I met our next speaker, Karen Selick. It was October 29th, 1989. I happen to know this because I was introduced to her by Dr. Walter Block, who came to a Freedom Party function to speak on the environment that morning. And although we don't really get to see each other too often except at events like this, which, by the way, is one of the great reasons to have these events, but we have kept in touch ever since. And I have to tell you, I've discovered her to be one of the most consistent and principled writers I have ever encountered. For us here in London, it is a delight when her articles make their way into the pages of our local London Free Press. It's like an island of rationality in a sea of confusion. And you see this one article sitting there at the bottom of the editorial page, and it's just crystal clear and to the point. And I guess more to the point in terms of my own interest, I suppose I have a personal vested interest in the subject matter on which she is about to speak, namely our so-called human rights commissions. I have more than once been quoted by the media as saying that Canada's human rights commissions are the closest thing that we have to a Gestapo. And the quotes are accurate. This is a conclusion I arrived at after I had the dubious pleasure of defending a local London landlord before a board of inquiry and a tribunal here in the City of London. And we won the first round, but lost the second one when the government appealed and decided that individuals aren't supposed to win these kind of cases. So anyways, you know what I think about human rights commissions. Let's find out what Karen thinks. Karen?
If ever there were a subject that could be called a motherhood issue, human rights would have to be it. Who except a radical misanthropist or a deranged nutcase could possibly be against human rights? Unfortunately, libertarians who live in Canada find ourselves in the distressing position of having to place ourselves in the anti-human rights camp. This is because when it comes to the phrase human rights, Canada has a split personality. When Canadians talk about human rights in some foreign country like China, Cuba, or Rwanda, we mean the right of individual human beings not to be murdered or imprisoned by their governments for offenses such as belonging to the wrong tribe or the wrong religion, or for speaking out in opposition to the party in power. But when Canadians use the term human rights here at home, it means something entirely different. Here, it means certain privileges granted under what we call our human rights codes. Every province in Canada has one of these laws, although they sometimes go by slightly different names. And then in addition to all the provincial laws, there's a federal law called the Canadian Human Rights Act. You can search in vain through these laws for any references to the rights to life or liberty. You won't find them. They aren't there. What is there are provisions outlawing discrimination by certain categories of people against other categories of people. Landlords, for instance, are prohibited from discriminating against tenants on the basis of their race, sex, color, age, and so on, through a long list of various protected criteria. Employers are forbidden from discriminating against employees. Businesses are prevented from discriminating against customers. In other words, what Canada calls its human rights laws are really a collection of laws outlawing discrimination. Now, I've been told that about half of the audience here today are Americans. You have the same kind of laws that I'm talking about, but instead of calling them human rights laws, you tend to call them civil rights laws. Your terminology is almost as garbled as ours. Surely if the phrase civil rights means anything, what it means is the right that citizens have as against the state. However, your anti-discrimination laws, like ours, go much further than merely governing the relationship between the individual and the state. They actually govern the relationships between one individual and another. But whether they're called human rights laws or civil rights laws, the glaring mistake that jumps out at libertarians is that the word rights is included at all. Because the word right is a very unique and very special word. Anyone who does any writing on this subject has probably run across the problem of not wanting to bore his readers by using that word right over and over again. But just try to find a good synonym for it. Look it up in the thesaurus sometime. There are no good synonyms. We reserve the word right to describe a rule of conduct which human beings have developed so that we can live together in society rather than as isolated individuals. Now, at the risk of making your eyes glaze over during this dangerous after-lunch time slot, I'm going to take approximately 2 minutes and 24.793 seconds, as Spock might say, for a brief excursion into abstract philosophy, and then I'll get back to more interesting stuff. Now, Jan Narveson covered some of this morning, but my formulation is going to be a little different and quite a lot shorter. As someone before me has pointed out, and I believe it was Ayn Rand, the concept of rights wouldn't be necessary for Robinson Crusoe living alone on a desert island. It's not a concept that defines man's interaction with inanimate objects, or even with living creatures incapable of reason. If Crusoe found himself standing in the path of falling rocks or a charging wildcat, trying to persuade them of his right to life wouldn't help him. In fact, if it detained him for even a split second, it would probably hurt him. But the moment Man Friday comes along and there are two human beings who have to coexist, the concept of rights becomes important. It's the moral interface between each individual and the society that he forms part of, however large or small that may be. The concept of rights allows human beings to live the best life possible to us, given the kind of creature we are. Human beings are unique among living creatures because we possess the faculty of reason. It's reason that makes it possible for humans to live a better life than brute beasts, by cultivating food, building houses, manufacturing clothing, trading our labor, and so on. But to act on the basis of reason, one must be able to exercise one's independent judgment. And to do that, one must be free from coercion by others. It's the concept of rights that allows human beings to live as neighbors to one another and to reap the enormous benefits that human cooperation can offer, yet still maintain sufficient barriers to protect individuals from coercion by others so that they can exercise their reason. If this is the correct understanding of why we have rights, it follows that all individuals must be entitled to the same rights. We're all in the same boat. We all survive by exercising our faculty of reason, and we all need to be free of coercion to do this. It also follows that rights belonging to individuals can't conflict. If person A, if you'll pardon my use of Jan's terminology, person A and person B, if person A has the right to violate person B's rights, then what B had must not have been a genuine right after all, because the very concept of right contains the built-in characteristic of inviolability. If B did have a genuine right, then by definition, A is precluded from violating it. Therefore, what A had could not have been a genuine right. This is the reason why I've taken to calling the anti-discrimination provisions of Canada's human rights laws phony rights or pseudo-rights. Whenever they're exercised, they invariably violate another person's genuine rights. Okay, that's the end of the abstract philosophy part, and I don't see anyone nodding off yet. So let me give you a few examples of what I'm talking about. I'm going to start with one that occurred right here in beautiful London, Ontario. It involves a disabled woman confined to a wheelchair. In 1988, she decided that she wanted to retain the services of a chiropractor. She made an appointment with a doctor here in London. He worked at a clinic owned by a second chiropractor, who was also the owner of the building where the clinic was located. When she arrived for her appointment, she found that the building wasn't wheelchair accessible. There were steps leading up from the front entrance room to the examining rooms. There was no ramp or elevator. She couldn't get in. She went home. She spoke to the chiropractor on the phone. He suggested 3 alternatives. First, he said, she could come back to the clinic, and he and the other chiropractor who owned the building would carry her up the stairs. Or, if she preferred, he would come to her home and treat her there. The third alternative would be that he would arrange to borrow facilities from another chiropractor who had a wheelchair-accessible building, and he would treat her there. The disabled woman wasn't happy with any of these suggestions. She complained to the Ontario Human Rights Commission, and they agreed with her. This was discrimination, they said. This was a violation of the disabled woman's rights. This was illegal. Nothing less would do but that the building be made wheelchair accessible. Now, the chiropractor who owned the building quite understandably resisted the notion that he should have to make alterations to his property for the sake of this one prospective patient. His building complied with all the existing zoning bylaws and building codes for the City of London. This patient might well decide after her first visit that she didn't like that chiropractor and would prefer to look for another one, or that she was cured of the problem that had sent her there in the first place and didn't need any more treatments, or that she was moving away to another city, or any of a dozen other things that would have meant that her first visit would also be her last. After years of negotiations with the Human Rights Commission, which accomplished precisely nothing, a board of inquiry was convened. The hearing finally took place in 1995, almost 7 years after the original complaint. In the end, the board ordered the chiropractor to install a wheelchair ramp leading from the parking lot to the first floor of the building. This would mean the loss of one parking space on the premises, the loss of one examining room, which would become too narrow to be used, and an expense of approximately $20,000. Furthermore, it would violate an existing zoning bylaw, and permission would have to be obtained from the City of London to make the alteration. But the board held that none of these factors constituted undue hardship and that it was the chiropractor's duty to accommodate the complainant. As well, the chiropractor was ordered to pay the disabled woman $500 for damages for infringement of her rights. So what we have here, needless to say, is an example of one person's so-called human rights trumping another person's property rights. The effect of this decision is tantamount to the Human Rights Commission simply expropriating $20,000 worth of the chiropractor's money and damaging his building into the bargain. There's no evidence at all that the spending of this $20,000 and the disfiguring of this building will ever benefit anyone, not even the complainant. If she needed chiropractic treatment back in 1988, there's a good chance she didn't wait 7 years for this decision to be rendered before going to another chiropractor. She's probably had her treatment long since, and she may never set foot, or should we say never set wheel, in this particular building for the rest of her life. In fact, if I had done to someone what that woman did to the chiropractor, I'd want to stay out of my victim's sight for a good many years, and I certainly wouldn't want to have him treat me. And it may turn out that this clinic will never get another patient in a wheelchair ever again, so this whole exercise may be for naught. Okay, so human rights laws have driven a stake through the heart of property rights in Canada. What other rights do they violate? My next example shows how freedom of contract is, if you'll pardon the expression, going to the dogs. In 1989, a woman named Sarah Donner purchased a residential condominium unit in Waterloo, Ontario, about an hour's drive away from here. The condo corporation's bylaws stated that no pets were to be kept in the building. When Ms. Donner signed her purchase documents, she agreed to abide by those rules. For more than 7 years, Ms. Donner lived elsewhere and rented out her unit to tenants. In 1996, however, she informed the condo corporation that she intended to move into her unit with her 85-year-old mother and her mother's small dog. Ms. Donner asked the corporation to amend the no pets clause. Her mother was totally deaf, and the dog had been trained to alert her to ringing telephones, smoke detectors, and so on. The corporation refused the amendment. Ms. Donner moved the dog in anyhow, and the corporation, supported by a majority of the unit holders in the building, sought a court declaration that she was in breach of the condominium's rules. The court held that enforcement of this contract that existed among the 172 unit holders would constitute discrimination against Ms. Donner's mother on the ground of her disability. It would not assist in enforcing the terms that Ms. Donner had knowingly agreed to. It said, quote, "The Ontario Human Rights Code has been enacted by the legislature of the province of Ontario for the benefit of the community at large and of its individual members. The parties are not entitled to contract out of its provisions. To allow the parties to do so would be contrary to public policy." End of quote. The court clearly understood that its decision would constitute a violation of the contractual rights of the other unit holders in the building. It attempted to minimize this violation by adding that its ruling was not to be construed as carte blanche for the dog to wander at will through the common areas of the building. It directed that the existing practice of taking the dog downstairs in a tote bag for its daily walk should continue. The court did not repeal the no pets clause. It merely refused to enforce the clause against an individual with a handicap. Presumably, an able-bodied occupant who tried to keep a dog in contravention of the rules would have met with a different fate. But where will the courts draw the line as to who gets to violate other people's contractual rights and who doesn't? Would an autistic child who showed some interest in a pet be considered a worthy case for protection by the Human Rights Code? What about an individual who is chronically depressed and claimed that his pet was one of the few things in life that gave him pleasure? This decision raises other interesting questions. While the unit holders in the building weren't permitted to compel Ms. Donner's mother to get rid of the dog or to move out, would they be entitled to damages against Ms. Donner for breach of contract? After all, she is not the person with a disability entitled to the protection of the Human Rights Code, and she did knowingly breach the contract that she had previously voluntarily agreed to. I wonder particularly about how Section 3 of the Ontario Human Rights Code would affect this case if anyone had bothered to look at it. Section 3 says, "Every person having legal capacity has a right to contract on equal terms without discrimination because of race, ancestry, place of origin, color, handicap, blah, blah, blah." I've always wondered just what this section might mean, given that the other sections of the code are all designed to override rather than protect freedom of contract. Would the non-handicapped unit holders be able to argue that they are entitled to as much protection as a handicapped person in the enforcement of their contracts, because if they didn't get such protection, they would be suffering from discrimination on the basis of handicap? What would happen if there were other occupants in the building who suffered from different handicaps? Suppose somebody in a nearby unit had an extreme allergy to dogs and found that the building's ventilation system was sending dog allergens into her living quarters. Or suppose another resident had a phobia of dogs, so severe that even the sight of a small dog in a tote bag in the elevator would trigger a panic attack. Whose disability would trump whose? The third type of genuine right that we find being ousted by so-called human rights with increasing frequency these days is the right to freedom of speech. Examples abound. There have been at least 3 cases across Canada of human rights commissions forcing mayors or town councils to declare gay pride days at the request of gay activists. In several of these cases, the municipal officials objected on the grounds of their religious convictions. They believed that homosexuality is immoral because that's what they thought the Bible says. As an atheist, I don't have much sympathy for their position. However, as a libertarian, I naturally respect their right to think and say whatever they want. Note, though, that these mayors and town councilors weren't hate mongers going around and spouting death threats toward gays. They weren't even campaigning for homosexuality to be outlawed. They weren't even refusing permission for the gay pride parades to take place. All they were asking for was the right to remain silent, something that our Constitution guarantees us in the case of a criminal charge, but not in the case of a so-called human rights complaint. One law professor from New Brunswick was even quoted in the Globe and Mail, one of Canada's 2 national newspapers, as saying that the refusal to proclaim Gay Pride Week could be considered inciting or promoting hatred against homosexuals. One of the more prominent cases of the Gay Pride proclamations occurred right here in London. The city seems to be a real hotbed of human rights problems. The former mayor, Diane Haskett, and the London City Council were fined $10,000 for refusing to make the proclamation. The Human Rights Tribunal also ordered them to make a public statement to the effect that the city's gay, lesbian, and bisexual communities are integral and important to the city. So, not only were they not permitted to remain silent, they were actually compelled to say something they didn't agree with. Every time I think about this case, the image of Howdy Doody comes into my mind. The London City Council was supposed to sit there like a dummy on the knee of the Human Rights Commission and say these words, but everybody would know it's the ventriloquist in the background who is really doing the talking. What on earth is this supposed to accomplish other than a display of naked power by the Human Rights Commission? Here's another example on freedom of speech. In 1996, the Toronto Star, and I think this is the newspaper that has the largest circulation of any in Canada, and I might add it's a very statist newspaper that's ordinarily a big fan of stuff like the so-called human rights laws. The Star found itself the subject of a complaint to the Ontario Human Rights Commission. A woman of Polish descent claimed that the Star had violated Polish Canadians' rights to equal service without discrimination. The Star had refused to publish a correction and 3 letters to the editor about an article on Poland that this woman disagreed with. To the best of my ability to determine, that case is still being pursued by the Human Rights Commission, although there's been very little publicity about it in the last few years. I actually emailed the Commission 3 weeks ago to see if I could find out what has happened to this case. The answer I got back by email was this, quote, "I cannot confirm nor deny if any such complaint exists in the system." Please note that only the complainant and the respondents may have access to a complaint that they are involved with, end of quote. I guess this policy of secrecy is supposed to comfort us that the Human Rights Commission is preserving our privacy. Anyhow, if this complaint does exist within their system, And if it isn't resolved by negotiation, and if the Commission then decides to take the matter to a board of inquiry, and if the board holds that the Star is guilty, then the code says that the board, and I quote, may direct the party to do anything that, in the opinion of the board, the party ought to do to achieve compliance with this act, both in respect of the complaint and in respect of future practices, end of quote. Among other things, this could mean that the board could order the Toronto Star to print the woman's letters to the editor, to pay her compensation for hurt feelings, and perhaps to publish a further statement about how important the Polish community is to Toronto. It might even require Toronto Star editors to attend some sort of sensitivity training so that they won't make the same mistake again. There are still other examples of the violation of free speech rights. In British Columbia, newspaper columnist Doug Collins was hauled up before the BC Human Rights Commission twice. Some of you who were at the ISIL conference a few years ago in Whistler may remember that Doug Collins came and spoke to us there. Anyhow, the first complaint against him was from the Canadian Jewish Congress regarding a column he wrote in which he referred to the movie Schindler's List as Swindler's List. That time, he was held not to have violated anyone's rights because the column wasn't strong enough to have been considered as promoting hatred. But then, outraged by the ordeal that he had been put through, Mr. Collins wrote 3 more columns about the Holocaust. This brought on another complaint, by a single individual this time. In round 2, the tribunal decided that Mr. Collins and his newspaper had violated the man's so-called human rights. It ordered them to pay $2,000 in compensation for injury to his dignity and self-respect. Now, just as an aside, I've always wondered how a person can claim that something that somebody else has said has made him lose his self-respect. I mean, self-respect is what you give to yourself. If someone else says something nasty about you, why should that change your opinion of yourself? Are you supposed to believe the other guy? Are you supposed to believe the other guy instead of sticking to your own opinion? And if you do believe the other guy, aren't you the one that's at fault, and shouldn't you have to compensate yourself? Anyhow, Canada's 3 most western provinces, BC, Alberta, and Saskatchewan, I know we have someone here from Saskatchewan. I told her I'd be talking about her province here. They've all gone out of their way to violate freedom of speech by actually writing specific sections into their human rights codes that explicitly prohibit certain forms of expression. And in fact, the worst offender is Saskatchewan, because it actually had the gall to include a little mini Bill of Rights at the start of its code, which it then proceeds to violate just a few sections later. Here's an abridged version of Saskatchewan's code, Section 5. Every person shall enjoy the right to freedom of expression through all means of communication, including the arts, speech, the press or radio, television, or any other broadcasting device. Then we go down to Section 14, which says exactly the opposite. No person shall publish or display in a newspaper, through a television or radio broadcasting station, or any other broadcasting device, or in any printed matter or publication, any statement which exposes to hatred, ridicules, belittles, or otherwise affronts the dignity of any person or a group of persons because of his or their race, creed, religion, color, sex, sexual orientation, family status, and so on. And then to top it all off, the very next subsection flip-flops again. It says, nothing in the preceding subsection restricts the right to freedom of speech under the law upon any subject. Figure that one out. The freedom of speech issue is a particularly interesting one for us here in Canada because unlike the first 2 rights I mentioned, property rights and freedom of contract, neither of which is protected in the Canadian Constitution, freedom of expression actually is guaranteed in our Constitution. And Doug Collins, who I mentioned before, is currently trying to have the BC Human Rights Code held unconstitutional through the courts. But he has a long, slow process ahead of him, and I, for one, am not confident that the outcome will be a positive one at the end of the day. Now, you Americans in the audience are very fortunate that your First Amendment rights are stated in very strong language. Congress shall make no law abridging the freedom of speech or of the press. Pretty strong. But here in Canada, our Constitution contains a weasel clause for every single right that it supposedly guarantees us. And I'm talking real rights here, like freedom of speech. The very first clause of our Charter of Rights and Freedoms says that all of our laws are subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society, end quote. In other words, whenever the legislature decides to pass laws violating our genuine rights, the Supreme Court gets to say whether those violations are justified. Now, isn't that one exciting rights guarantee? The free speech violation is bad enough, but just last month, we Canadians learned that there's something even worse in store for us. A panel of so-called experts has recommended that our federal Human Rights Act be amended so that in addition to violating property rights, freedom of contract, and freedom of speech, it would then violate just about every economic freedom you can imagine. The Human Rights Commission in Canada is poised to become the economic dictators to the country. How can this happen? Well, the experts have decided that outlawing discrimination on the basis of race, sex, color, and so on isn't enough. Now they want to outlaw discrimination on the basis of something they call social condition. What on earth is social condition, you may ask? Does it mean having halitosis or body odor? Does it mean being an obnoxious bore or a hopelessly shy geek? Actually, none of the above. Social condition is being used pretty much as a synonym for poverty. Why bother with a synonym, you ask? Why not just say poverty? Well, the committee that recommended these changes answered that one. They said, the term poverty should be avoided because there is no consensus about its meaning or measurement. As if there's a consensus about the meaning of the term social condition or its measurement. In any event, just think for a minute about what it will mean for businesses to be forbidden from discriminating on the basis of poverty. One of the big beefs that the so-called human rights activists have is that poor people, and especially welfare recipients, sometimes get turned down by banks for loans and mortgages. Surprise, surprise. Well, now banks won't be able to do that. They won't be able to use standard income tests or debt servicing ratios to determine whether or not a person qualifies for a loan. They'll have to judge each case on an individual basis without using any guidelines by doing individualized reference checks and credit histories and deciding whether or not to believe this person when he says he'll make the mortgage payment his top priority instead of spending his welfare check on other stuff. Needless to say, this is going to increase the cost of loans for every other customer. Just processing loan applications under these conditions will cost a lot more than it used to. But the number of bad loans is also likely to increase, and that will raise the cost of borrowing for everybody. But that's only the start, because, the panel of experts tells us, social condition doesn't just mean poverty. It also encompasses certain other related conditions, such as illiteracy or homelessness. So suppose a homeless person decides he'd like a $50,000 loan too, even though he has no house against which the bank can register a mortgage. If the bank refuses, wouldn't that constitute discrimination on the basis of homelessness? In fact, my prediction is that this new prohibited ground of discrimination will be the jumping off point for an all-out attack on the market system. The very act of fixing a price for your goods or services could be construed as an act of discrimination against the poor because they'll obviously be less able to afford your product than the rich. Now, everyone in this room knows that merchants don't use prices as weapons of discrimination against the poor. In fact, we greedy capitalist pigs aren't known for turning away business merely because a potential customer is poor. Usually the criticism is that capitalists exploit the poor, which means at the very least we must be doing business with them. But if we look at what radical egalitarians call adverse impact theory that's been developed over the past few years, I think my prediction falls squarely within the realm of possibility. So pretty soon I expect that human rights laws will violate not only the rights to property, contract, free speech, but also the right to determine the selling price of your products. The Human Rights Commission will become the economic dictators to the country just as much as the government ever was in the former Soviet Union. The question that always comes to mind whenever I ponder laws like these is this: are the people who drafted them really so stupid, or are they simply evil? I haven't reached a decision on that one. I think there's some of each. But one point I always try to make clear is that these laws don't really have anything to do with preventing discrimination on the basis of race or color or other irrelevant personal characteristics. How can I tell? because the laws are lopsided. They apply in only one direction. Landlords can't discriminate against tenants, but tenants are perfectly free to walk away from a vacant apartment if the landlord happens to be black or Jewish or elderly or handicapped. Employers can't discriminate against employees, but employees can legally discriminate against employers. Storekeepers can't discriminate against customers, but customers can pick and choose on the basis of race, religion, sexual orientation, or any other arbitrary criteria the stores that they wish to patronize. Newspapers can't discriminate against readers, but readers can discriminate against newspapers. Now let me be absolutely clear that correcting this lopsidedness by outlawing discrimination in both directions would only make things worse, not better. That's certainly not what I'm advocating. But my point is that there is some method in this apparent madness. If you look at the people who are prohibited from discriminating, they all have one thing in common. They're the sort of people who are presumed by status to be wealthier than the people they are being forced by law to deal with. Landlords own the rental premises. Tenants don't. Employers own the business. Employees don't. Storekeepers own everything in the store. Customers don't. Of course, this presumption of unequal bargaining power is probably wrong a good percentage of the time. Landlords, employers, and storekeepers aren't always rich. Their assets might be mortgaged to the rafters. A good many of them are struggling to get by. Tenants, employees, and customers aren't always poor. Nevertheless, the intention of the so-called human rights laws is clear. The people who are denied the right to determine how their property will be used, the people who are denied freedom of contract, are the people who appear to have assets. They appear to have wealth in one form or another, buildings or businesses. And the so-called human rights laws are designed to deny them the benefit of using their wealth in the manner they choose. These laws are designed instead to place their wealth at the disposal of people who don't own it. In other words, the goal of these laws is to impose a form of thinly disguised socialism, to redistribute the benefits of property ownership without going through the hoops of actually seizing and redistributing the property. Taking away people's property tends to make them very angry, but telling them that you are merely enforcing human rights, that's another story. You can probably make them feel guilty enough to get away with that. You may have noticed that throughout this speech, I've made a point of always referring to the human rights laws as so-called human rights laws, and I noticed in his introduction that Bob Metz also used the phrase so-called human rights laws. I suspect, Bob, you must do the same. I think it's important for libertarians to defend freedom not as the Canadian Civil Liberties Association does by wimping out and saying, these laws are right in principle, but they're just being carried too far. Libertarians must denounce these laws as wrong in principle, wrong from the very start, and destructive of true human rights. Thank you.
We have time for a few questions. We have about 10 minutes.
What's your impression of the likelihood of the expansion of the human rights legislation being enacted?
The one that I was talking about, the federal one, I think it's almost a sure thing because this isn't something new that this panel just came up with. Actually, you can go to the website of the it's called the Canadian Human Rights Act Review Panel, and their website is chrareview.com or .ca probably. And you can see this is something that the Commission itself has been pushing for a long time. I know that I wrote about this more than 2 years ago when the Human Rights Commission wanted this, and what they did, what Anne McClellan, our Justice Minister, Federal Justice Minister, did to accommodate them was she set up this panel of 4 experts. One of them is a former Supreme Court of Canada Justice and some law professors and so on. And if you look at the website, they put out one of these one of these advertisements that they always do for people to make submissions, and then they held meetings in different cities all across Canada. And if you read on the website the submissions that were made, you can see that the only people who ever attended these things were all in favor of this. I mean, there were all these poverty groups and human rights groups, so-called, just one after another, they made the submissions about how necessary it is to make poverty a prohibited ground of discrimination. So if the Liberals remain in power, I think they will bring in this legislation.
Whatever happened to common sense was the question. The gentleman with the mic, and then Jim, and then Chris, and then we'll see if we have time after that.
I don't know if you're aware of this, but I think you'd like to be if you're not. The Wall Street Journal publishes polls, respected poll, fairly regularly, and it shows that when you leave out the capital L on libertarian, or you just describe generic terms, as much as a third of adults in America now prefer to call themselves libertarian. I think the reason is that they're fed up with the kind of things you describe happening in Canada. And one of the worst places we hear about in the United States are the college campuses. They've taken the Civil Rights Act and President Johnson's decisions on it and carried it to such extremes. You can be brought to local courts, kangaroo courts on campus. The only rescue you may have is when you finally take it out to the outside court system. It's the worst place. One story was that one guy yelled at a sorority making a lot of noise. They were drunk and boisterous. He said, "You water buffalo."
Yeah, I know the
You've
water
heard
buffalo.
that story?
I know the water buffalo one. Yeah.
And it wasn't until it got to the outside regular court system that the university officials were told, you can't take away rights on the grounds of that. And we found out water buffalo is a Hebrew phrase meaning boisterous and bumptious. So.
Yeah, you've been lucky that way because, as I said in my talk, you've got the First Amendment, which is very strong. But I've just recently, for another talk that I gave about a month ago to the Society for Academic Freedom and Scholarship, there's a couple of people here that belong. I researched the actual decisions by our Supreme Court, and there have been some very bad decisions by the Supreme Court of Canada on this subject, and they've painted themselves into a corner because the decisions that exist already were decisions that were made in connection with anti-Semitic literature. So, the decisions that the complaints were about under human rights codes about people who were, Holocaust deniers and really blatantly anti-Semitic, and the stuff that they were putting out was, very offensive. And the Supreme Court said, instead of looking at it as a matter of principle and saying, well, yes, this stuff is offensive, but we want to uphold the right to freedom of speech, they said, oh no, this stuff is perfectly constitutional, and in effect that the human rights laws can override the freedom of speech. So, it would be very difficult for them to retreat from that now. You could say, well, what will happen if they get a much more ambiguous case, of the water buffalo, for example? I don't know what they'll do because they've already said that these laws are constitutional. So where can they go from there? Are they is every case going to have to go to the Supreme Court to decide whether or not this particular speech was an offensive one?
My question was regarding the lack of tangible evidence that there are rights. You can't reach out and measure them or touch them. So what gives you faith that any rights exist?
I don't think it's a matter of faith. I think that that it's you can't reach out and touch them. They don't come down from the sky, and I don't believe in God, so I don't believe God imposed them. Rights are pardon?
God doesn't believe that either.
Yeah. Rights are a convention that human beings have adopted. They are a code of conduct that we have adopted, and if you want to live in a civilized society, you have to accept the fact that there are these conventions.
But if we adopt good ones, can't we adopt bad ones?
Well, you can adopt bad ones. Obviously, we do adopt bad ones. If you believe in majority rule, you can adopt all sorts of horrendous things. But that doesn't mean that we shouldn't talk about trying to adopt only the good ones and only the correct ones that apply to everyone and that can be universally respected without violating other people's rights.
Yeah, Karen, a lot of people don't realize, maybe you talked about London being a hotbed for various kinds of violations in this respect. And Canada, I think, has really been pretty bad at this kind of stuff. And right here on this campus, a few years ago, we had a couple of professors put on trial for word crimes in the classroom. And a lot of us fought very hard to end this. And I think in the end it was a hard fight to get clear of, but we eventually prevailed, people like myself and Ken Hilborn and a bunch of other people on campus. And right now, this university is pretty much clear of this kind of stuff, although there's still a little bit of it running around. But the thing I could never really understand is why administrative organizations go along with this stuff, because a lot of it really doesn't make any sense at all. And I thought maybe you might be able to shed some light on that.
Because these organizations are essentially funded by the state in the first place and therefore have a tendency to attract people who believe in this kind of stuff. I suppose that would be my short answer. You know, if we abolished all the subsidies to universities and all those people had to go out and get jobs, they'd be too busy, you know, real jobs in the real world, satisfying customers who were really willing to pay. They'd be too busy to spend their time on this stuff.
I know we have a lot more live examples in the audience and everybody's dying to tell them, but we'll have to share them later in the speakers lounges. But I wanted to thank you, Karen, very much.